for us to start. My name is Jay DeVoy. I'm of counsel in the Las Vegas office of Holland Hart. Joining me today are my colleagues, Connie Ackridge, a partner in the law firm, and Sydney Gamby, one of our associates. All of us focus extensively on healthcare issues. Our information can be seen on this next slide. We're here today as part of the ongoing boot camp series of webinars to talk about state-specific issues that affect healthcare delivery, and today we're speaking about Nevada-specific issues. We have a brief syllabus on one of the slides that is coming up, and we'll be talking about a number of things. Before we begin, we want to give a couple of disclaimers that the comments made today do not necessarily represent the opinions of Holland Hart. They represent the opinions and the experiences of the individual speakers, and they are not construed to be legal advice. They're not tailored to any specific fact or circumstance. Much of what we're talking about today are things that are being proposed and are not yet codified into law. And for that reason, none of this should be relied upon as being relevant to a specific legal question that any of our attendees might have. That being said, there is time for questions and answers at the end. We will answer general questions to the best of our ability as they relate to the items that we're discussing today. As seen here, we have the overview of what we'll be discussing today, and most of this discussion will be focused on the upcoming legislative session that begins in a few weeks. The way that Nevada's legislature works is a little bit different from other states. Our legislature only meets once every 2 years, and then for a period of only 120 days. And during that time, bills have to move forward fairly quickly, or they die and they have to be resumed at a subsequent legislative session, or perhaps dealt with via regulation by an agency or entity that's able to pass and enforce those regulations when the legislature isn't in session. So for that reason, we have a lot of bills to cover. There's a lot of activity that's going to happen. A lot of it has been influenced by COVID-19, both from a standpoint of identifying ways that the state's healthcare apparatus and care delivery mechanisms can be made more robust, weaknesses that have been exposed by the pandemic, and then also the concern about cost that's been imposed based on damages to Nevada's budget. The governor recently released a budget. He restored most significantly the Medicaid cuts that had preliminarily been made at the start of the pandemic to try to conserve state funds. So it seems like public financing for healthcare in that regard will be restored, or is projected to be restored to normal levels. But there have been other adjustments that have been made or will have to be made or kept in place throughout the rest of the state. And for that reason, that's going to influence a lot of what happens in the coming legislative session and a lot of what we're going to be discussing today. And I think those concerns are reflected throughout the legislation that is being proposed for the upcoming session. Other things that we'll be discussing about once we discuss the legislative changes will be the waivers and the immunities that have been put in place during the declared an ongoing state of emergency within the state of Nevada regarding COVID-19. We'll also be discussing the requirements of Nevada's medical record retention laws, which differ in subtle but important ways compared to other states adjacent to Nevada. And then we'll be discussing Nevada's corporate practice of medicine doctrine and also Nevada's prohibition on self-referrals, which would be commonly known as a state Stark or mini Stark statute. The most significant thing that we have to bring to bear, though, the thing that, for those of you who are familiar with Nevada, changes the most frequently and changes in ways that are not well understood until after the fact, are the changes that are made by our legislature on a biannual basis. So if we can go to the next slide, where we'll be talking about the behavioral health changes that are forthcoming. There's about a half dozen bills, really 5 bills and 1 bill draft request that, to the best of my knowledge, has not yet been reduced to a bill, but likely will be, covering a wide range of topics that all relate to behavioral health. What the pandemic has done is really revealed the deficiencies in the state's behavioral health delivery mechanism. There are a lot of private participants that are doing a lot for the community and that do a lot of the work that absolutely has to be done to preserve the mental health of the community. But the concern that has arisen is that there's not that care available for everyone, and has led to inequitable outcomes in terms of the communities that are being served and having their needs met, and other communities that have a need or have an undiagnosed need, and those needs are going unmet. So one of the most significant changes that's going to be made is the idea that's set forth in SB 56, which is Senate Bill 56, and it's going to require private payers to insure and pay for telehealth behavioral health services and not require in-person visits. And it's a pretty straight line to get from the coronavirus pandemic to that level of care and making sure that people can receive behavioral health services and make sure their insurance covers it without having to have in-person visits. Some of this is oriented towards the patient and for patients that don't want to have to leave the home, but also for providers, which are necessarily more limited in number and also might prefer to have virtual or FaceTime meetings over a secure platform in order to have those interactions with their clients and their patients, without having face-to-face interactions, especially for practitioners that might be immunocompromised or that fall into other risk categories for coronavirus. The problem with these changes, you have to really dig into the bill to see them. So that's why we want to make sure that we provided the bill identification numbers, such as SB 69 and SB 70. These are the titles that are actually given. So a lot of things sail through the legislature without people quite understanding what is going to be in the bill until it's fully read and comprehended in its proper context. So SB 69, which revises behavioral health provisions, that has to do with creating an entirely new series of behavioral health provider known as peer counselors. And it discusses the services that are going to be provided by peer counselors and the way that they would be regulated by the state. The idea of a peer counselor, it's somebody who doesn't have a formal degree, so it wouldn't be a master's in social work, it wouldn't be a clinical social worker, it wouldn't be a psychologist or a licensed marriage or family therapist. It would be somebody who is working in a care delivery environment and is providing services based on their lived experiences in order to provide coping mechanisms. Obviously not prescribing any kind of substances. They don't have the formal training to use things like cognitive behavioral therapy in a professional way, but at the same time, they are providing these support services, and the idea is to have these people on the radar if they're going to be involved with the continuum of care and to make sure the state knows who they are and what they're doing for a number of purposes, to protect patients and also to ensure that there's some level of accountability in case a facility is failing to perform or if there's concerns about the quality of care that's being given. So for that reason, there's this area where there are people who are performing not purely administrative or facility maintenance tasks within these facilities. They're not just performing nursing tasks. They kind of fall in this area where they're involved with the delivery of care, but they're not a licensed care guy, a caregiver. And for that reason, they would fall within this category of peer counselors and would be subject to the regulations that are being proposed in SB 69. That is something that's been flagged as potentially being an unfunded mandate for the state. So it's something that may or may not ultimately pass due to budgetary implications, but it's also weighted against the need for these kinds of services and this level of personnel and care within the state to deal with the behavioral health crisis that has emerged as a result of COVID-19. So for that reason, it's uncertain what direction this is going to take, but just for future reference, even if it doesn't pass in this legislative session, I think the emphasis that has been placed on behavioral health in Nevada is not likely to fade away anytime soon. And this is an idea that might come back in the future in a different form or in the same form in a year when there are fewer budgetary concerns. SB 70 and SB 36 frequently work the same way. They have to do with pretty significant changes to the way that mental health holds. SB 70 specifically deals with mental health holds and involuntary holds for youth, but SB 36 proposes some significant changes throughout the entire system in terms of how the judicial process interacts with the mental health holds for adults and for minors and for people under the supervision of another, such as a parent or a guardian. And it requires a pretty aggressive use of the judicial system to obtain orders and for judges to sign off on the use of chemical restraints. One of the reasons the chemical restraints became so significant is that in the behavioral health context, the use of physical restraints and the use of other means to keep people restrained to fundamentally protect themselves is a frequent topic of concern, and it's a frequent survey subject when being evaluated by state and federal regulators. So for that reason, a lot of facilities have turned to, or at least considered the viability of using chemical restraints to effectively sedate somebody to the point where they don't have to be physically restrained. There are a number of legal questions that come up with that because of the substances that are being used, some of them being controlled substances, how they're delivered, how they're dispensed, and the dosages and other consequences of using these drugs. So the idea of SB 36 and SB 70 kind of pulls these all together so that SB 36 specifically deals with the restraint components, among other things, for restraining adults for voluntary or involuntary holds, and also requiring them to go to intensive outpatient therapy beyond the period of the initial hold. And then SB 70 specifically deals with mental health holds for youths. I'm familiar with one instance in particular where a youth was held beyond the 72 hours that was allowed, and once the facility was alerted to that, the youth was promptly let go. So there is a need for that, just based on the limited experience that I've seen and heard of that, and it's something that likely will end up influencing the way that mental health services are delivered throughout the state, and also the way that it's going to potentially affect the way that youths are held and released from these facilities. The other payment provisions have to do with payment. For example, SB 44 includes revisions to Medicaid and other payments and requires that social workers be among the group of professionals that are compensated for behavioral health services. And that's really the biggest change there. And then the other change that was made was for SB 36. Within school districts, it's a small but potentially important change that reflects the current moment that the school districts are having in Nevada. I'm sure many read the New York Times article about how the Clark County School District, which is one of the largest school districts in the nation and embraces not just the city of Las Vegas, but all of Clark County, where there's about 2 million people, between 2 and 2.5 million people. And the number of suicides among students is forcing the school to reopen earlier than expected. And to contend with that and to balance the competing needs of both the virus and also the mental health of students who are ailing when forced to learn from home in different environments. And for that reason, this bill requires, if it were to pass, will require the county or the regional health district to have a board on a developmental board that is overseen by the county school district in order to specifically contemplate pandemic response, which would deal with not just the health crisis, the immediate health effects of it, but also foreseeably the collateral mental health effects that arise from what we have seen happen with COVID-19 and periods of extended restriction that apply not just to adults, but to school-age children as well. So in the next slide, we'll be dealing with pharmacy and drugs, and Cindy Gamby will be speaking about this issue and the changes that are anticipated to be before the legislature in this session.
Yes, so I'm Sydney Gamby. Thank you for the introduction, Jay. And the pharmacy and drugs bills that are anticipated to come before the legislature in this session, there's no bill text for any of them yet. They're all BDR, meaning bill draft requests. But most of these bills that are listed on this slide, in fact, all of them but one, all of them but 40-546, are sponsored by the Committee to Conduct an Interim Study Concerning the Costs of Prescription Drugs. This committee was created by Senate Bill 276 in the 2019 legislative session, so the last session, last regular session, to conduct an interim study concerning the cost of prescription drugs in Nevada. Also, the impact of rebates, reductions in price, and other like remuneration from manufacturers on prescription drug prices. The committee started by acknowledging recent legislation that Nevada already passed surrounding prescription drugs, including legislation regarding drug pricing transparency for drugs that treat diabetes and asthma, forbidding gag rules, preventing pharmacists and pharmacies from discussing less expensive drugs or alternative payment options with consumers, legislation creating a prescription drug donation program in Nevada, and legislation creating a patient protection commission to review issues related to healthcare needs of Nevadans and the accessibility, affordability, and quality of healthcare, including prescription drugs. So these new BDRs, which I'm just going to talk about a few of them, there are proposals for what those would include from this committee. So, for example, 40-443 would allow the Department of Health and Human Services to establish intra- and interstate purchasing coalitions for prescription drugs. So that would be to consolidate the purchasing power of agencies within the state or of different states to obtain bulk prescription drugs at a lower negotiated price from wholesalers or from drug manufacturers. Pharmacy benefit programs and commercial health plans would also be able to join an intrastate purchasing coalition, or at least that is the proposal. Whether this ends up in a final bill remains to be seen because there is no bill text yet. 54-444 would require the licensure of pharmaceutical sales representatives by DHHS. Drug manufacturers are currently required to make certain reporting about their active sales representatives in Nevada, but there's no current licensure requirement of the pharmaceutical sales reps. So this BDR would require licensure of those sales reps. 40-445 would expand existing price transparency rules, those ones that are applicable to asthma drugs and diabetes drugs, beyond those types of drugs, and increase reporting on wholesalers, insurers, and PBMs, or pharmacy benefit managers. 57-446 would amend some statutes concerning pharmacy benefits managers, PBMs, including requiring licensure of PBMs by DHHS, prohibiting PBMs from using spread pricing, which is where the PBM keeps the difference between the price paid by the health plan to the PBM for prescription drugs and the amount reimbursed by the PBM to the pharmacy for the drugs. So typically that money flows from health plan to PBM to pharmacy, and the spread is what the PBMs would keep. That would be called spread pricing. This bill would eliminate that. Instead, PBM's only source of income would be disclosed administrative fees for services. All manufacturer discounts, incentives, and other fees collected by the PBM must be reimbursed to the third-party payer, and rebates would be passed down to patients. The contracts between PBMs and third-party payers would need to be fully transparent, including with respect to rebates, discounts, product pricing, incentives, and the like. The bill would also require PBMs to allow their clients, the health insurance providers, third-party payers, full audit rights, including of pharmacy claims, rebates, and similar information. It would also establish a fiduciary responsibility for a PBM to the third-party payer, such that the benefit of the payer is the primary and sole interest of the fiduciary PBM. And this is important because it would create this fiduciary duty where the PBM has to put the payer first. 57-442, that bill would require at least half the health plans in Nevada to have prescription drug coverage with no deductibles from the first day the health plan coverage commences, fixed prescription co-payments at a flat dollar amount per prescription rather than percentage, and limited co-payments of not more than 1/12 of the patient's annual out-of-pocket spending maximum. And that would all be based on the individual plan, how much that out-of-pocket maximum and the like is. As far as 40-546, there's not really much information on that bill out there yet. It is sponsored by, I believe it's Senator Harris. But to the extent that there is bill text that comes out on these bills, there'll obviously be more opportunity to analyze what those bills would require and how those are going to change as they track through the legislature. And on our next slide, we have some other healthcare bills, which Connie Ackridge will talk about.
Good morning, everyone. There are a number of other healthcare bills that are being proposed this session. We've listed them all, not all of them, but a great deal of them. I'm going to talk about 3 of the bills, specifically SB 40, AB 47, and SB 5. The thing those 3 bills have in common is they all relate to access to care. And given Nevada's well-known shortage of physicians, and also that combined with access issues created by the COVID crisis, I think that's why we're seeing so many access to care bills, because there's a concern that not everyone's getting access to care. Let's start with SB 5. This bill relates to telehealth, and what it does is it orders the Department of Health and Human Services Director to establish a data dashboard that allows for the analysis of data relating to access to telehealth by different groups and populations in the state. So the dashboard has to include data concerning healthcare services, behavioral health services, and dental health services provided through telehealth. And it has to allow the user to sort data based on race, ethnicity, ancestry, national origin, color, sex, sexual orientation, gender identity or expression, mental or physical disability, income level or location of residence of the patient, type of telehealth service, and any other category determined by the department to be useful. So what that says that the data dashboard is established to review access to different groups and populations in the state through telehealth and evaluate policies to make such access more equitable. So that's the purpose of the data dashboard. It also, the bill has a insurance coverage component, which requires there to be parity in payment for services delivered via telehealth compared with other delivery methods. So that's, I think, the most important part of SB 5. Turning to SB 40, sort of another access bill, and it's for those of you who are familiar with the transparency laws that were passed during the Trump administration. And there was a TV drug price disclosure rule that was struck down as exceeding HHS authority. But then there's a hospital price transparency rule that became effective January 1st, 2021, which requires hospitals to disclose their standard charges. And then there's a federal transparency and coverage final rule that was issued on October 29, 2020, that, among other things, mandates that group health plans and health insurers and individual and group markets to disclose to enrollees personalized out-of-pocket cost information and the underlying negotiated rates. So SB 40 is sort of the Nevada transparency rule, as it were. But what it does is it requires the Department of Health and Human Services to establish an all-payer claims database of information relating to health insurance claims resulting from medical, dental, or pharmacy benefits provided in the state. So the claims database requires insurers to basically provide all the claim information to the state to populate this all-payer claims database. And Section 12 of the bill pretty much tells you that the state is anticipating, or the proponents of the bill sort of anticipate that the information will be used by those who want to conduct research, to assist patients, providers, and hospitals to make informed choices concerning care, enable providers, hospitals, or communities to improve performance by allowing comparison with other providers, hospitals, and communities as applicable, enable purchasers of healthcare to identify value, build expectations into purchasing strategies, and reward improvements over time, or promote competition among providers, hospitals or insurers based on quality and cost. Those sound like some of the objectives of the federal transparency legislation. The final bill I want to talk about is AB 47, which revises provisions relating to unfair trade practices. The first thing it does is requires all parties who are required to file notification under the federal Hart-Scott-Rodino Antitrust Improvements Act of 1976 with the DOJ or the Federal Trade Commission to simultaneously file a copy of the intended merger or acquisition with the Attorney General at least 180 days before the merger or acquisition. And this is if any party has exceeded $5 million in gross sales to consumers in the state in any of the 3 years immediately preceding the merger or acquisition, and the aggregate value of the voting securities, assets, and other interests to be acquired or merged exceeds $25 million. So it authorizes the Attorney General to issue written investigative demands within 30 days of the filing, and it imposes a civil penalty for violations of the notice requirements. The other significant changes that this bill wants to make are to impose limitations on restrictive covenants and agreements. The bill would specifically repeal NRS 613-195, which was added in 2017 to define non-compete provisions which employers may enforce against employees. So AB 47 would eliminate all employer-employee non-compete provisions and allow only provisions, restrictive covenants, non-compete provisions to be allowed in relation to the sale of a business. So AB 447 makes it unlawful to enter into an agreement which restrains a natural person from engaging in a lawful profession, trade, or business of any kind, and any such agreement is void and must not be given effect to the extent it violates the bill and constitutes an unfair trade practice under NRS 598A.060. But, as I said, it does not prohibit a person who sells a business to agree to a non-compete in a specified geographic area in which the business is sold or in which the seller has been carrying on the business so long as the buyer or any other person deriving title to the business or goodwill from the buyer carries on a like business therein. So sales of business is very broad under this proposal. Includes selling the goodwill of a business, all the person's ownership interest in the business, all or substantially all the operating assets and goodwill of the business, all or substantially all the operating assets and goodwill of the subsidiary of the person, or all of the person's ownership interest in a subsidiary of the person. It also applies to a member of a partnership or an LLC upon or in anticipation of the dissolution of the partnership or LLC, respectively, or disassociation from the partnership, LLC, respectively, which may also enter into a non-compete. Perhaps the most interesting part of AB 47 is the restriction on exclusive agreements between medical providers and hospitals or hospital systems. And providers very sort of broadly defined to include not only physicians under Chapter 630 and 633, but also PAs, licensed nurses, dispensing opticians, optometrists, practitioners of respiratory care, physical therapists, occupational therapists, licensed psychologists, or perfusionists. So basically, unless an exclusive agreement is approved, it's not only an agreement, but a policy approved by the Attorney General, the following agreements are void and unenforceable. Any provision in an agreement between a provider and a provider organization and hospital, which grants the provider or provider organization the right to be the exclusive provider of a specified healthcare service for the hospital or hospital system. So this could be, a cardiology group signing up with a hospital to be their exclusive cardiology group. That would have to be approved by the Attorney General ahead of time. Or any provision in an agreement which prohibits a provider or provider organization providing a specified healthcare service for a competitor of the hospital or hospital system. So there's a provision in the contract that says that cardiology group can't provide any services to a competing hospital, has to be approved by the Attorney General's office. Also, any provision in an agreement or policy of a provider organization, hospital, health system, or health carrier that prohibits a hospital system or health carrier from purchasing healthcare service from a provider organization or a provider organization from selling a healthcare service to a hospital or hospital system or health carrier, or an agreement between a hospital or hospital system and health carrier that restricts the ability of the health carrier to encourage a person to obtain a healthcare service from a competitor of the hospital or hospital system. All of those are void and unenforceable unless approved in advance by the Attorney General's office. So the bill contains a process to seek Attorney General approval for the agreements, and the criteria the Attorney General uses to determine whether it will approve such an agreement are as follows. The agreement or policy is likely to result in an increase in the welfare of the consumers. Such increase in the welfare of consumers cannot be accomplished through alternative means that are less restrictive, and the agreement or policy does not constitute a contract, combination, or conspiracy in restraint of trade as described in NRS 598A.060 subsection 1. So there are penalties for not seeking approval, for entering into such agreements through the court, and otherwise, not only for civil penalties, criminal penalties, injunctive relief, but also other equitable relief for violations of the provision of this chapter, including disgorgement or restitution. So this provision is, I'm sure it will create a lot of discussion with the legislature. I'll just put it that way. So appreciate you listening to my presentation today, and thank you so much.
No, thank you. There's a lot of interesting stuff coming in front of the legislature, and The one thing that Sydney talked about, I wanted to quickly track back on, there was a bill draft request about end-of-life prescribing of medication, and just an interesting thing about Nevada, because other states seem to be addressing this. There's a group of people, I believe they're based out of D.C., they're a Death with Dignity group, and they've been pushing this Death with Dignity legislation in Nevada. It's been introduced in a number of prior sessions. And in the state of Colorado, relatively recently, when they didn't get traction from the legislature, they had Death with Dignity legislation ultimately adopted by going to a public referendum. So it's interesting to see how that comes up over and over again in the Nevada legislation, and it's being proposed by Senator Harris this time. I don't believe it's ever made it to a floor vote. Last session it went out of committee. I don't know what will happen this session, but it is something that is happening nationwide. So it's interesting to make note of that trend specifically because for our listeners, wherever you are within the firm's footprint, either this has already become law in your state, such as the cases in California and in Colorado, or it is something that is likely being pushed forward and will be adopted either through legislation or through a public vote. So I just want to draw special attention to that, and the many issues that Connie brought up as well about the changes that require additional disclosures under Hart-Scott-Rodino to the state of Nevada in addition to the federal authorities. Now we're going to talk quickly about COVID-19 waivers. Sydney Gamby is going to talk about this and the Declaration of Emergency Directive 11 and the various sections within it that have to do with immunity and waiver of specific regulatory and other provisions within the state of Nevada by the governor.
Thank you, Jay. So Declaration of Emergency Directive 11 is, it's got about 13 sections. I'm not going to go through each and every one. I'll just kind of hit the highlights. But Section 1, the big one, waives the licensing requirements for unlicensed skilled medical professionals during the COVID-19 crisis. And this includes all skilled personnel deemed necessary by the governor's COVID-19 medical advisory team. There are some specific ones listed on the slide, listed in the directive itself, including medical doctors, physician assistants, nurse practitioners, APRNs, RNs, LPNs, EMTs, advanced EMTs, respiratory care practitioners, paramedics, pharmacists, pharmacy technicians, medical students, nursing students, medical laboratory directors or technicians, and licensed or certified behavioral health professionals. Section 2 applies the waiver to qualified providers of medical services, so those personnel deemed necessary, during the emergency who hold a valid license in good standing in another state, and that would include those with suspended licenses for licensing fee delinquencies or failure to meet continuing medical education requirements, and retired providers. Does not apply to revoked or voluntarily surrendered licenses under a disciplinary proceeding. So if there was a disciplinary proceeding and that licensee surrendered their license voluntarily or had their license revoked, the waiver would not apply to those types of providers. Section 4 says that those seeking waiver and exemption of the licensing must notify the applicable Nevada licensing board or agency. So each licensing board or agency has their own way of doing this. Some of them have a form that you provide to them, such as the Board of Nursing or any of these other boards. But that notification must happen to take advantage of the waiver or exemption. You can't just practice without that notification to the appropriate licensing board. Section 7 allows practice outside of a provider specialization, but only within the limits of their competency, and to the extent necessary to augment and bolster Nevada's healthcare system during the crisis, the COVID-19 crisis. So you can practice outside of your scope of specialization, but only within the limits of competency. This becomes important as well in the recent Nevada Health Response Guidance that was issued on January 14th, 2021 regarding administration of the COVID-19 vaccine. So this waivers discussed in Directive 11 would apply to individuals delivering that COVID-19 vaccination as well. Section 10 of Directive 11 affords those providers performing services for emergency management the immunities and protections in NRS 414.110. And those immunities are listed on this slide. The immunity would not extend to willful misconduct, gross negligence, or bad faith, but it would extend to those workers who are in good faith trying to deliver those emergency services related to emergency management. They would not be liable for death of or injury to persons or damage to property within the scope of this immunity. Section 11 waives licensing fees for new applicants, and it delays licensing fees for existing licensees during the pendency of Directive 11. But this does not entitle anyone who's already paid fees to refunds. There's also no suspension of a license for unpaid fees during the period of the directive or for a period of 60 days thereafter. So no suspending licenses for unpaid fees during this time. And Section 12 similarly says that there's no suspending licenses for administrative reasons. That would include continuing education requirements, deficiencies. The licenses could still be suspended or revoked for things like jeopardizing patient health, such as incompetency or malpractice, however. And Section 13 just says that Directive 11 remains in effect unless it's modified or terminated by a subsequent directive. Now we'll move on to record retention in Nevada. So that is governed in Nevada by specific statute NRS 629.051, and it states that the custodian of healthcare records have to maintain the healthcare records of patients for 5 years after their receipt or production. And this is unless a longer time period is mandated by federal law. So in some cases there may be a longer time period, but the Nevada time period is the minimum of 5 years. Those healthcare records may be retained in a written form. They may be retained by microfilm or some other recognized form of size reduction, such as microfiche, computer disk, magnetic tape. They may be created, authenticated, and stored in a computer system, which meets the requirements of Nevada statutes. And those statutes are found at NRS 439.581 to Section 439.595. and the regulations that are adopted in the Nevada Administrative Code pursuant to those statutes. There's some other obligations on healthcare providers concerning record retention. Healthcare providers must post a sign in a conspicuous place at each location where healthcare services are delivered, advising that the records may be destroyed after 5 years. And the healthcare provider must provide a disclosure to the patient at the first visit where the patient receives healthcare services that records may be destroyed after 5 years. If that disclosure does not occur at that first visit, then it has to occur at the next visit. That disclosure may also be provided at any other time, so it could be provided more often than that, than just the first visit. And it can be combined with other paperwork that's provided to the patient, such as other intake paperwork or disclosures that the healthcare provider may provide. There are some specific rules that are applicable to patients under 23. Healthcare providers may not destroy the records of a patient under the age of 23. So if the patient's under the age of 23, those records cannot be destroyed even if it's been 5 years. If the patient attains the age of 23 and the records have been maintained for 5 years or longer, any longer applicable federal period, then they may be destroyed. But both must be true. The patient must be 23 years of age and the records must have been maintained for 5 years. So for example, if the patient becomes a patient and healthcare records start being created at 21, those records would not simply just be able to be destroyed at 23. You have to wait the full 5 years before you do anything with those records, destroying them. There are some requirements under Nevada law for how to handle requests for records from patients and the like. They largely track federal law in those areas. We didn't go into them today just for lack of time. but those are in the same chapter, that Chapter 629. And now we'll move on to the Nevada self-referral statute, which Jay DeVoy will talk about.
Thanks, Sydney. Nevada has a self-referral statute that, as I mentioned at the beginning of the call, operates in a manner somewhat similar to the Stark Law. Unlike the Stark Law, which applies only to Medicare and allegedly Medicaid payments, there's some dispute among the courts among that, with many of it interpreting it to apply to Medicaid, even though the statute specifically only says Medicare. Nevada Revised Statute, or NRS, Section 439B.425, prohibits a practitioner's referral of patients directly or through an intermediary for healthcare-related goods or services to any health facility, medical laboratory, diagnostic imaging or radiation oncology center, or other commercial establishment without limitation in which the practitioner has a financial interest, unless a number of restrictions apply. Nevada, being a largely rural state, allows for the referral of services to a commercial institution or medical facility where the practitioner has a financial interest if the service is not otherwise available within a 30-mile radius. Not as significant within the Reno, Carson City metro area or in southern Nevada, but for other parts of the state, such as Elko and other areas in between, like Pahrump, it could be very significant to do that. For another example, is referral to an HMO participating provider from another member within the HMO. That's almost treated the same as a group practice, even though it's not strictly a group practice, the distinction being that the group practice is owned wholly by the practitioners within it, whereas the HMO is a separate entity that's licensed and regulated by the Commissioner of Insurance. And that goes to a corporate practice of medicine issue that we'll talk about in a few minutes. But there is an allowance for referrals to be made within an HMO and other providers within the HMO as if they were members of a group practice, which is also, as seen in point C, one of the allowable referrals, just like it is under federal law. If you are a surgeon, you refer to another surgeon who has privileges at a hospital or a surgery center on another part of town, which is inconvenient to you for an emergent case, then it's not going to be a referral. But there are restrictions on that, where the group practice requires that the people actually be members of the group or employees of the group the same way they would be under federal law, as opposed to just giving a referral to somebody else and having some self-described group that exists. Also, a referral made to an ASC does not count as a referral for the purposes of this law, reason being that many ASCs are owned by physicians, whether by a specific group of them or other physicians who come together to do their cases there. So while there are restrictions on what ASCs can do, they're largely set by the Division of Public and Behavioral Health and other constraints that are put on them by the anti-kickback statute if they're accepting Medicare or Medicaid money. And in order to comply with the relevant safe harbors, for the purposes of this statute and self-referral in Nevada, referring a patient to an ambulatory surgery center does not count as a self-referral. And on the next slide, there are a couple of additional examples of exceptions to the referral, the prohibition on self-referral. If we just go to the next slide. And then there's additional referrals that are permitted under the statute, specifically for urologists for lithotripsy services and nephrology just for renal dialysis. This also follows federal law where lithotripsy and kidney issues receive special treatment, and that's reflected here in the self-referral prohibitions in Nevada. The allowance for referrals to publicly traded entities or a financial interest that's represented by the ownership of securities in another entity. This is quite a bit larger than the federal equivalent. Federal law sets the threshold for investments in a large entity at $50 million, whereas Nevada sets it at $100 million. But for large enough publicly traded entities, this is unlikely to be a problem, just to be listed on one of the stock exchanges. If you get down, you're talking about an entity that's listed on a penny stock exchange, then it might be an issue to reach the $100 million valuation question or even the $50 million one. But for most companies that are going to be listed on the New York Stock Exchange or NASDAQ or other prominent exchanges, this is likely not going to be an issue. And then another issue that seems to be very common in Nevada is a referral made by a physician to a rural surgical hospital in which the physician has an ownership interest along with other requirements. That is something that is an interesting legacy case, just given the way that the Patient Protection and Affordable Care Act largely eliminated physician ownership of hospitals. But there are some legacy hospitals that do have physician ownership in them. They were generally established, they were all established before the ACA, and they continue to exist. In Nevada, there are other restrictions on physician ownership of hospitals that I believe predate the ACA, and other states probably have done similar things. But in rural areas, I'm familiar with a few, specifically in Arizona, where there is at least one physician-owned hospital that I'm aware of that predates the ACA. This is something that comes up, and it largely happens in rural areas or in communities that have enough population for a hospital but are relatively secluded. So these are issues that do come up from time to time. Now, the important critical distinction in all of this is that a practitioner is not prohibited from using and owning equipment in his or her own office solely to provide his or her patients services or goods related to healthcare. This is the idea that self-performing something is fundamentally not a referral, and owning and using equipment for your own services also is not a referral. Now, what this does not specifically allow, though, is the idea that you own product and you're going to allow someone else to use it on a per-click basis, which is something that federal regulators have long looked askance at, with the idea that somebody charges rent based on a per-scan or per-use metric of equipment, such as an MRI or other item of diagnostic testing utility. Then on the next slide, we have some more information about the corporate practice of medicine. As I mentioned earlier, what is going to happen in Nevada for HMOs is that they're regulated by an entity other than one of the health boards, namely the Board of Medical Examiners for MDs or allopathic physicians, and the Board of Osteopathic Medicine for osteopathic physicians. And if we go to the next slide, there's a bit of an evolution of the corporate practice of medicine. It's never been codified in a specific statute. It largely emanates from 3 separate Attorney General opinions that have been issued beginning in the 1970s up to 2010. And since there hasn't been much use. But the corporate practice of medicine is the doctrine in Nevada that specifically does not allow for corporations that are not wholly owned by physicians, whether they're DOs or MDs or a mix of the two, to directly employ physicians and allow them to practice medicine. There have been holes that have been poked in this doctrine, so it's not a clear bar where it has to be a professional corporation or a professional limited liability company to specifically employ physicians, but rather there have been exceptions that have been recognized where in cases of extreme need, in the 2010 opinion, the Attorney General recognized that there's tension and inconsistency in Nevada law that could be interpreted that would permit hospitals under certain circumstances to directly employ physicians, but there was an issue that the Attorney General's office said that the legislature needs to squarely address one way or the other to clarify what the law is going to be on this issue. So people have drawn different things from that opinion. There are a number of provisions in it that can be read to allow in certain specific limited circumstances the direct employment of physicians, but it's not a bright line rule, and that only pertains to hospitals, and the inquiry was made specific as to hospitals. Otherwise, some of these businesses that come up that want to directly employ physicians, such as medical spas, where somebody knows a lot about aesthetics, they know something, or rather they know a lot of people, or they have a lot of experience in the world of say like managing salons or other retail business where people come in and buy high-ticket items, and part of that would be Botox or a face peel or some other aesthetic procedure. That is something that would not allow the direct employment of physicians. Sometimes there's a physician that either owns the entire practice and that's their professional entity, or they're contracted with that practice and they're not actually acting as an employee of it. But there are other exceptions to it as well, like ownership of a medical facility is generally not deemed to be the practice of medicine. As mentioned above, there are protections for physicians and also safe harbors for physicians that want to own part of a surgery center or own part of another medical facility. That ownership interest isn't necessarily the practice of medicine. It's the activity that happens within it. And that largely is due to the fact that you could be a non-practitioner and still have an ownership interest in some of these facilities, such as a surgery center. And as noted at the end of the slide, though, the trend is to limit physician ownership of medical facilities to avoid potential conflicts of interest. As noted, there's the anti-kickback statute safe harbor that essentially limits physicians from investing in more than 3 surgery centers because of the surgical and procedural requirements necessary to comply with that safe harbor. Limitation on referrals to physician-owned DME distributors and point-of-sale services, and then, as noted previously, the Affordable Care Act's prohibition of physician ownership in hospitals. So the reality is in Nevada is that there are narrow exceptions for entities that can potentially employ physicians, but the general rule is that physicians can only be directly employed by professional corporations or a professional limited liability company that is set up and wholly owned only by other physicians. And the next slide, there's a little bit more information about this. One of the matters I talked about before, we can go to the next slide quickly. And then the idea of what the Attorney General's opinions are based upon just the requirements for the licensee to be a person, and then the prohibitions about making sure that the professionals have independent discretion and they can exercise the professional judgment to act in what's the best interest of the patient in order to make these determinations and in order to act in the interest of what's going to be best for the patient. If we go to the next slide, we can talk a little bit more about the specific opinions. The first opinion that was issued by the Attorney General's office stands for the general proposition that I've discussed, where physicians can only practice medicine and be employed through professional corporations. This predates the rise of professional limited liability companies, although they're organized under Chapter 89, and for that reason, professional corporations and professional limited liability companies, both of which can exist under this Nevada Revised Statute, Chapter 89, which has to do with professional entities, they are deemed to be able to both directly employ physicians on that basis. But this opinion is significant for recognizing that HMOs, due to being regulated by the Commissioner of Insurance and being subject to greater scrutiny, such as utilization review and having a license that can be revoked, they were entitled to directly employ physicians as well, due to the strong similarities between the employment of their license that was issued by the Division of Insurance and the licenses that were issued to individual physicians by the medical boards. And then the intermediary opinion is discussed in the next two slides, and that was issued in 2002. So it's a long gap between the 1977 opinion. To give an idea, this is basically the gap between the original Star Wars coming out when the prequels began being issued. And that was in 2002 when the second opinion on this issue was issued. It largely reiterated the points that were made in the first. There was still no kind of precedential background that was interpreting or construing what the corporate practice of medicine was. It confirmed that the PCs, the professional corporations, can only render professional services related to medicine, homeopathy, and osteopathy. But it grew upon the 1977 opinion that HMOs, due to being regulated by the insurance commissioner, can directly employ physicians, and it extended it to medical dental services organizations, prepaid limited health services organizations, and managed care organizations, which are created under different chapters of the Nevada Revised Statutes, all of which, though, fall within the title that pertains to insurance. On all of these entities were regulated by the Division of Insurance and the Insurance Commissioner, and subject to the same regulations or similar regulations to HMOs that the Attorney General concluded entitled HMOs to directly employ physicians in 1977. And we just have one last slide about this advisory opinion. And it has the question of if the corporate practice of medicine usurps the authority of the state to protect the public. And it's a question that the Attorney General's office is contended with by allowing the corporate practice of medicine only in these specific circumstances where all of the shareholders of the entity, such as the professional corporation, or if the entity itself is subject to a licensure requirement, the license can be revoked and is subject to oversight by a regulatory authority. So that concludes the material that we had to discuss today, and I'd like to throw the floor open to questions if anybody would like to submit them in chat. Our contact information is at the end of this slideshow, and these slides will be available online if they aren't already. Similarly, if there's any problem using the chat application, I believe Laura Squires, who organized this, she can receive questions via email and send them to us. And if there are any questions, one of the team can respond to you, depending on if it's about a legislative issue or one of the substantive issues that we discussed today. I'll wait a little bit longer to see if anyone's going to send a question in chat, but otherwise, thank you for your time today. We're grateful to have the opportunity to share this information about Nevada, both the state of the current law and laws that might be forthcoming based on the new legislative session that's going to start shortly, and could potentially change the shape of certainly behavioral health, pharmacy benefits, and a number of other areas of law, such as telehealth and telehealth reimbursement over the next coming years. Depending on what the legislature ends up doing and how active the citizenry of Nevada is in advocating for what they believe should be passed and what our legislative priorities should be.